Well, it's interesting. I've been doing DUI work for 32 years. 6.5 of those years I was a prosecutor. The remaining 26 or so years, been a criminal defense attorney. The debate rages on about whether to take the breath test or to refuse the breath test. It is so situational, and there are some penalties for refusing to take a breath test that are civil in nature, and they involve your driver's license. So you have to, but you're not really going to be thinking about that when you're pulled over on the side of the road. You've got the takedown bar lights flashing in your eyes. You're out of the car. They're going to be giving you field sobriety test or field sobriety exercises. They're going to read you implied consent, and they're going to ask you to take a breath test or a chemical test. And it's the test at the choosing of the officer. It could be a breath test. It could be a blood test. I've even handled cases years ago, urine test. How do you beat a DUI? I was kind of dealing with the issue of, do you take the breath test or not? It's situational. It really depends. The more you believe you're not impaired, sometimes the more you are impaired. But if it's truly a situation where you've had 1 or 2 drinks and there's been a substantial amount of time that has passed, it might not be a bad idea to take the breath test. You may very well be under a .10 or under a .08 now in Florida. And the problem is, though, sometimes people are small in stature, small in body. Everyone's metabolism is different. And just because it's under a .08 doesn't mean you're not guilty of DUI. The statute reads that if it's a .04 to a .08, it can go either way. Under a .04, you're presumed to be not impaired.
So, okay.
And the key here is impaired, not drunk. It's a much lower standard for the government to prove it's not drunk. And the government hates that word, and they're going to fight. And truthfully, they'd be entitled to a jury instruction from the court that says you don't have to prove he's drunk. You have to prove he was impaired. Sometimes a refusal case is a lot easier to, I hate to use the word beat, but to get a much better result for a client, because it's one less piece of evidence that the government has. But don't forget, that also entitles the prosecutor to argue the implication of not taking the breath test. There's a reason why. It's the old criminal guilty mind. That's why the test was not taken. Of course, there are legitimate reasons for not taking a blood or breath test, and those can be explored as well. There's so many factors that come into the defense of a DUI case that oftentimes when we have thoroughly vetted and investigated a case, we've come up with many strategies that have proven to be very successful over the years, either to defeat the case in toto or at least get the case at the prosecutor's discretion bumped down to a reckless driving or some other diversionary type program for DUI.